Welcome to Footprints and Impacts, the podcast where we uncover how the environment shapes our health and well-being. Whether you're curious about how chemicals in your surroundings affect you, or you're looking for practical ways to live a healthier life, you're in the right place. Brought to you by the Environmental Health Association of Canada and the Environmental Health Association of Quebec, this podcast shines a light on multiple chemical sensitivity, MCS, the importance of healthy, least toxic product choices, and what it means for those navigating this disability, where over 1 million Canadians have a diagnosis of MCS. We're here to raise awareness, offer resources for accessibility, prevention, and build a healthier, inclusive community. Let's dive in and explore how our footprints leave a lasting impact on our health and our planet. So, hi everyone, welcome to Footprints and Impacts. I'm your host, Marco, and today we're diving into some really important conversations about disability rights, specifically around multiple chemical sensitivity, MCS. We're privileged to have Lila Refaie, did I say that right? With us today from Arch Disability Law Center. Arch has been a key player in disability rights in Ontario since 1979, fighting for justice and equality, especially for people with disabilities who might be facing financial challenges. Today we'll talk about the work Arch does, the legal support available to people with disabilities, and the major issues with disability law that Lila and her team are tackling right now. Whether you're personally impacted by disability law or just curious to learn more about how disability laws applies to MCS, there's lots to take away from this conversation. So let's get into it. Lila, thanks for being here.
Thank you so much for inviting me to speak today.
It's always great to have great guests, and I'm sure you'll bring a lot of insight to our guests and our listeners. So. Lila, you've been engaged in this field for quite some time. Could you share how you first became involved in human rights law and what inspired your focus on disability rights in Canada?
Sure, absolutely. Essentially, I've been from the start of my legal career working in more the broader social justice law. I started working in a general community legal clinic in a small town in Ontario, where the focus was a lot more on what we call poverty law. So that includes, people who are receiving social assistance, for example. So that's where I started off, and then through that work, I was there for a number of years, and simply wanted to do a bit more, or take my career a bit to the next level, um, and really focus, more so on disability law within, the social justice aspect of my focus. And and that's when essentially I applied to work with Arch Disability Law Center, and was essentially hired, obviously. And I've been there since 2017. So that's really what the focus is really now more so about for me. Um, and what really drove me to take that next step in my career is that um, essentially, Arch is what we call a test case clinic. And what that means is that we not only do legal work to resolve individual cases, but we look at issues within the disability community and disability law on a broader level, and try to bring systemic changes, and really try to bring some changes within the system itself to better the rights of persons with disabilities across the province of Ontario.
That's great. That's great. Thank you so much. And let's say Arch's mission, right? So Arch has been a leader in disability rights in Ontario, like I mentioned before, since 1979. Could you share a bit about the clinic's mission and how it's made such a big impact on ensuring justice and equality for people with disabilities, especially those facing financial barriers?
Yes, absolutely. So for your listeners that may not be aware of who Arch is, who Arch Disability Law Center is, I will say Arch just for short from now on, but essentially Arch is a specialty legal clinic. We are based in Toronto, but we have a provincial mandate. Um, and because we are a specialty legal clinic in based in Toronto, our mandate is really focused into the province of Ontario. We do work as well on a more national level, but our main focus is Ontario. We are funded primarily by Legal Aid Ontario. So when we talk about specialty legal clinic, essentially our focus is on disability rights. We assist persons with disabilities directly who are living in Ontario, and about issues related to what they're experiencing in Ontario. So part of our mission is, of course, to advocate for the rights of persons with disabilities, and removing systemic barriers. Um, and we do talk a lot about, the rights of all persons with disabilities because as well, we are primarily funded by Legal Aid Ontario. We do also have that focus of people who with disabilities who are also living under the poverty line or near the poverty line. So sometimes that brings in another different aspect or to the additional barriers that they may experience. Um, we also try to achieve those systemic changes or remove those systemic barriers by providing awareness and education on the rights of persons with disabilities, whether that's directly to the person, the community of persons with disabilities, because they may not know their rights necessarily in all situations, but also in situations where, uh, you know, bringing awareness to like members of parliament, right? Whether that's at the Ontario government or if it's a federal issue with the federal government as well, so that way we could bring some changes through there. Um, and like I mentioned, like we are really focused. Our work is focused with issues that happen in Ontario, but we do as well do some more national work at times. And what I mean by that, like we do some federal work in terms of, for example, transportation. Some transportation issues are provincial or municipal, like buses or local buses, while other types of transportation issues are federal, right? So that would affect the rights of persons with disabilities across the country, such as your rights when you're taking via rail train or when you're taking an airplane. Um, but again, like we do start off with someone with an issue that originated in Ontario, right? To be able to tackle that issue. Um, and we also, do use a lot of international law as well when we can, such as the Convention on the Rights for Persons with Disabilities, or maybe some people may know it better by the CRPD. So we do try to bring that in to any of the work that we are doing. Um, and yeah, I think that's mainly, what we work on. We do focus on very specific areas of law, which are informed by by our communities of persons with disabilities, that they've essentially told us what exactly they need us to work on, right? So
Yeah, so it's like it's they come in, they explain their situation, and you guys find the right solutions for them, right? So it kind of shapes itself as it goes.
Yeah, exactly, exactly. And more specifically, too, if I could go off from what you just mentioned, like we do, I mentioned this earlier, we do a lot of test case litigation. So we go to court, we bring those big cases to make those changes. We talk to government, and we try to bring changes through that way as well, which is not always through a lawsuit or a litigation. Could be through, policy changes or trying to make changes in the laws that are already existing, or trying to bring politicians to create new laws that are better for rights of persons with disabilities. But more individually as well, how we help our communities as well, is that we do also provide free legal advice to persons with disabilities in Ontario, specifically about their issue. So while that may not necessarily always be like this in a systemic manner, but we do those one-on-one calls as well, so that we could help persons with disabilities, advocate for themselves as well in their particular situations.
Yeah, it's amazing work. That's for sure. We need more and more people like you to continue doing this work. Lila, you mentioned you've been with Arch since 2017 and playing a key role in providing these legal services to the community. Could you tell us more about your crucial part in Arch's mission?
Yes, absolutely. So, my official title, I am the bilingual staff lawyer. So that means I can provide services in English and in French, which we have found is very, very crucial. Even though we are based in Ontario, there is a big number of Francophones that live in Ontario. So we do provide, that dual, those dual services. And as a staff lawyer, you know, I we I basically work on every single aspect of Arch's mission in a different way. We are a smaller team, but we all kind of contribute, on different work and different files and cases. So that includes, representing people in their case at either a tribunal or a court, providing the legal advice to persons directly about their issues, presenting rights workshops directly to persons with disabilities or to organizations, to bring that awareness as well. And I also work as well on some law reform projects that we have going on in that sense. Yeah.
Yeah, that's great. That's great. And having mentioned the whole bilingual side of it, I'm gonna let our our listeners know that we're gonna be redoing this episode in French, so they'll also have access to it in French. So thank you for that. But it's a good. I'll plug in our next episode while we're doing the English one, just so our English listeners could let their French counterparts know that we'll also be covering these questions in French, which is great for our community and great for our listeners as well. So, as you know, the Environmental Health Association of Canada, our main focus is MCS, multiple chemical sensitivity, and MCS is recognized as a disability under the Canadian Human Rights Act. Could you break down what this means for people living with MCS in terms of their legal protections and rights? I know you had mentioned there's a distinction between Canadian and Ontario human rights, but if you could just fill us in the best way you can.
Absolutely, absolutely, and thank you for that. So yeah, I do want to first start off with making that distinction, between the Canadian Human Rights Act and provincial human rights laws. I will obviously focus on Ontario. Um, so in Ontario, we have the Human Rights Code, um, which is very similar to the Canadian Human Rights Act. The difference between those two laws, is basically where which um, which law would apply to your situation depending on what you're dealing with. So what I mean by that is that there are certain things that or certain situations or areas that fall under what we call the jurisdiction of one type of law versus the jurisdiction of another type of law. And we talk a lot, like what we mean by that is really about federal laws versus a provincial law. So the Canadian Human Rights Act is really only about what is federally regulated or falls under the federal jurisdiction. So that means essentially, any dealings you have with federal agencies like Service Canada, for example. Banks is also a big one that falls under the Canadian Human Rights Act. And I mentioned this a bit earlier, but federal transportation, like via rail, planes, and yes, some buses that if they cross over between one province to another, that would fall also under federal jurisdiction. Whereas provincial jurisdiction and what will fall under the Human Rights Code of Ontario is basically whatever is whatever falls, under the provincial government kind of control. So for the most part, it's basically everything else that's not federal, right? So your housing, for example, going to the doctor, issues with the doctor's office, services that you receive when you go to the store, or when you're going to the restaurant, um, municipal buses, right? And schools. Most jobs would fall under the provincial as well, unless you work at a bank or a federal agency. So really, those are two different laws that is important legally in the sense of where you're going to file a complaint if you need to file a complaint. But essentially, both laws pretty much are very closely identical in terms of the rights and protections that it brings to people. So I just wanted to make clear about that distinction before we get into, what are the legal protections and rights for persons living with MCS. So essentially, MCS is recognized under human rights laws as being a disability. Is recognized as being a disability. So what that means is that under human rights law, there are certain protections that come into place for someone with a disability, such as MCS. And both the Canadian Human Rights Act and the Ontario Human Rights Code are really focused on what we call specific social areas. What that means is that the legal protections that those two laws have are not necessarily for every single aspect of someone's life, but it's really focused on specific social areas where there is a relationship between the person and the party that is violating their human rights. Some examples of the social areas that, or people living with MCS, are protected or have protections and rights. We talk about services, employment, housing, education, and these are just some of the examples of the social areas where you would have, but there has to be some relationship between the two parties. And I'm saying this because I do want to maybe just specify further that, if you are walking down the street and you're being discriminated against by a random person, that is just a passerby on the sidewalk, you pass them by, they tell you some kind of comment, or they treat you differently. In most situations, that would necessarily bring you wouldn't necessarily be able to bring a human rights complaint against that stranger that you're just walking down the street with, right? Which is different than if you're going to a restaurant and the restaurant employee or manager or whoever that is working at that restaurant denies you the right to go in, right? Or doesn't accommodate you or says you can't come in because you have a disability. That situation you would have that relationship with the restaurant and have some protections, right, to the right of access to their services. So essentially what it means, that MCS is recognized under human rights law as being a disability is that there is some protections in place, such as the protection against being discriminated against, having any ableist comments or some mistreatment because of your disability. And it also includes the right to get accommodations from the other party that you would need because of your disability in order to access either the service or in terms of to be able to work at your place of employment, for example, as well. So, and I believe we'll probably be able maybe to get into it a bit later on, but there is those two big rights right there for persons living with MCS. That comes with being recognized as a disability under human rights laws.
Okay. And what about, like, could you say anything about the right to safe, accessible air for people with MCS?
Sure. I could maybe say a few comments about the right to safe and accessible air. Um, so essentially this is, something that is very important in human rights law. And that does bring in, the whole idea of universal design and the fact that people living with MCS, can really enter or go through any area or any place in society where they would have, they wouldn't have to worry about whether the scent-free policy is being followed or not followed because there is, that
Mm-hmm.
that accessibility already in place right then for them without having to ask for it. Um, so it kind of goes a bit further than the right to be accommodated in the sense of, it's like society taking a proactive measure, right, in universally designing the places, the society or the different aspects to kind of preempt um, that kind of accommodation and just ensuring that it is universally accessible in the same way that there are, automatic doors or ramps, right? That is basically you don't need to ask for it because it's something that should already be there as an accessibility measure.
Exactly. So this kind of covers that question about how it's such a crucial principle in human rights law to have the right to safe, accessible air, especially when talking about people uh, with MCS. You
Yeah,
know,
absolutely.
so in terms of workplace accommodations for people with MCS, when it comes to the workplace, what are the legal responsibilities of employers to accommodate employees with MCS? Could you walk us through what the process looks like to request and negotiate these accommodations?
Sure. Sure. So employers have, whether they're federal employers, provincial employers, it doesn't matter. They have the same legal responsibilities. Um, and that is that they have what we call a duty to accommodate their employees, um, including employees with MCS. That duty is only to the point of undue hardship, and I could touch quickly on what that means, but just to focus on really the duty to accommodate specifically right now. Essentially what that is, that if one of their employees has MCS or is living with MCS, and they require some accommodations due to their MCS, then the employer has to essentially provide, the accommodations that is needed for that employee. And that could come through in different ways. One of the way that could essentially get started or begin is if the employee approaches the employer to say, I need accommodations because I have MCS, or even just you could just say, because I have a disability. And then at that point, once the employer is made aware about that there may be some need for accommodations, that triggers their duty to accommodate. And I'll go through, what that process looks like or what happens after they become aware. But just before that, I do want to also talk a bit about a different way that duty to accommodate can be triggered, which is essentially that the employer kind of suspects that there may be a need for accommodations for one of their employees, and then they approach or they ask that employee if they need accommodations. So that's what we call in human rights law the duty to inquire. So regardless of how it starts, whether it's the employee that approaches the employer first, or the employer is inquiring or investigating about whether or not there is an accommodation need, once that is triggered or that's discussed, then the employer has to conduct what we call an accommodation process. And that could look a little bit different from employer to employer, obviously, but essentially what the accommodation process is, more in general terms, is that one, the employer has to figure out or with the employee what the disability related needs are. In most situations, the employee doesn't have to necessarily disclose the nature of their disability, but there may be situations where that would be required. For example, in situations where the employer needs to get some extra funding, right, to accommodate, and to get that funding, you have to confirm that you have that disability, right? Those may be one example among many others that may have a requirement for the employee to disclose the nature of their disability. But the employer can't force, in most situations, they can't force the employee to disclose the nature of their disability. What the employer can do is that they need to do this, basically, is to have the employee or to ask the employee what are the disability related needs. So in cases of employees with MCS, a lot of times that would be a scent-free environment. And there may be other situations, other examples of accommodations, but just for time's sake, I'll focus on the scent-free environment as an accommodation. So the employer can sometimes ask for additional medical information about those needs, or about what kind of accommodations to meet those needs. And that's perfectly fine. And unless it's an unreasonable request, it's, employees should, at least cooperate with the employer with some information, because all this is really for them to better understand what the needs are in order to better accommodate the person. Now, employees don't necessarily have to tell the employer exactly what the accommodation is or what the solution is. That is on the employer to figure out. But a lot of times persons living with MCS already know what accommodation they would require, and that's perfectly fine if you want to tell the employer, like this is the accommodation that I would need. Just I'm just mentioning all this because there may be some of you that may not know what accommodations should be in place. You know what your needs are, but not what accommodations should be in place. And the employer cannot say, well, we're not going to accommodate you because you didn't tell us what the accommodation you needed. That's not on the employee to tell. That's the employer to figure out what accommodation should be in place. So there would be some requests for additional information if needed. A lot of times there are meetings between the employer and employee. For unionized employees, there may be an additional process in place. At Arch, we don't advise unionized employees, so I wouldn't be able to tell you specifically what their process is, but just if you have a union, then I think the first step would be to speak with your union representative about that if there's anything else you need to do. And then once the employer gathers all the information from you, they may also consult some experts or some organizations. Of course, it would require your consent for the most part, so you would be aware of that. But once they get all the information and then they figure out, okay, this is the accommodation we could provide, then they would let you know or give you an accommodation plan in writing. And then the next step after that would be for the employer to actually implement the accommodation plan or implement the accommodation that they said that they will do for you. Now, after all that is said and done, and you have the accommodation plan, that doesn't mean that the employer no longer has responsibilities. They have an ongoing duty to accommodate as long, during the entire employee-employer relationship. What this means is that just because they did one accommodation plan, if it's either not working, if that plan is not working, or there needs to be some changes to that plan, whether to add more accommodations, remove some, or change the ones that they had already put in place, then the employer has to basically check in, right, with you, or you can also let your employer know that you need to review the accommodation plan. But there is that ongoing, responsibility to ensure that the accommodation plan is still okay, or, is there any changes that needs to be made? And then if there is, then the accommodation process kind of starts all over again in terms of they need to gather the information, need to figure out what the new accommodation should be, and then draft a plan. So essentially, what's really important is that the employer really understands what the employee's needs related to MCS are. And that's something the employee can tell the employer. And just one last thing to wrap up this question, is that employers need to understand that every person has individual needs. Every person, you could have 10 employees with MCS, doesn't necessarily mean it would be 10 identical accommodation plans. Everyone has individualized needs. So just because an employer tells their employee, well, this is what we're doing for all situations where of accommodations related to MCS. If you have other needs as well, or need a different kind of accommodation, then the employer still has that duty to accommodate your individual needs specifically.
Yeah. And I imagine people with MCS, because they have so many different uh, symptoms and different conditions and different needs of accommodation, they must face a lot of challenges, right? So, what are the most common challenges people with MCS face at work, and what could organizations, employers do to break down those barriers and make workplaces more accessible?
Yeah, absolutely. There are so many challenges that people in MCS face at the workplace. I think one of the more common ones that we hear a lot about is that a scent-free policy is not being followed by their colleagues, by other employees. If it's a workplace that's open to the public, by members of the public. It's not always necessarily a scent-free policy that's not followed by the employer, but by other people in the workplace, which is a huge challenge, I think, with the particularly with those kind of policies. Um, there are also, you know, a lot of barriers in terms of what we call an attitudinal barrier, like really where the employer may not believe that the person has MCS or believe that there's accommodations. I think that's still a more um a widespread, maybe just like ideology issue, right? In terms of really, I don't know if the law could change that. It's really more of a society issue. But that is a challenge, though. That I still want to mention that makes it that there's barriers for persons with MCS when they're trying to get accommodations. Um, there is also some barriers put up in place where the employer would be asking for way too much medical information um, with regards to their MCS or the employee's medical condition or MCS specifically. And that can put a lot of barriers as well and challenges for the employee in terms of they're trying to get accommodations. And the employer keeps asking for more and more information. And it could be problematic for many, many reasons, that repeated request. One, it delays, getting the accommodation in place, right? Sure, we can all agree that it's not that quick to get, medical information from your doctor. Or if you're seeing a specialist, it takes time. So that delays even further the accommodation process. But also there is a privacy aspect to it. Employers don't necessarily need or should have that much information about your medical history or anything like that. What the employers have to do or are allowed to have is strictly limited to what is related to the disability needs, right? It's not about, what happened 7 years ago when you went to the doctor or you went to the ER. Really just about what are your disability related needs at work and that needs to be accommodated. And it's information about that. And as well, asking for too much medical information is also a challenge in terms for people who may not have family doctors or may not have access to that kind of medical expertise to be able to provide that information. And also for persons living with MCS, there is um, a very distinct challenge or even a barrier um, where it's almost like they have to quote unquote test an accommodation to see if they'll be triggered. So it's like almost having them to be forced to be triggered and have a reaction to see if the employer is properly accommodating them or not, which is a huge challenge for people living with MCS in that sense as well. Um, so I think one of the main things um, beyond beyond the legal responsibilities, in terms of what an employer should or shouldn't do um, under human rights laws. Um, on a more practical sense, I think to break down these barriers and making their workplaces more accessible, I think it's really important that there is education about human rights laws, about legal responsibilities, about MCS in the workplaces, right? So by the organizations that they become aware of exactly, what it means to accommodate people and what are the barriers and how, that they're facing in their own organization that they may or may not be aware of it necessarily. So I think that would probably be the biggest thing that people could do.
Yeah. Yeah, and I mean we see it more and more nowadays where these big institutions are starting to adopt scent or fragrance free policies. I mean, it's not entirely widespread just yet, but
Mhm.
it's starting to come into the general population, especially in big public places like certain hospitals, certain clinics have started to put up scent-free policies. I know some major banks have also started to implement, but like you said, if everybody doesn't feel like not wearing fragrance, that causes its own problems, and someone with MCS has to test is someone actually, you know, wearing
Mhm.
something, or is something in the office causing me to have a reaction. So it's like asking someone who's in a wheelchair to try the stairs.
Mhm.
It's
Exactly.
it's
Absolutely.
and we would never do that, but that's what I think people need to start understanding about MCS and multiple chemical sensitivities.
Mhm. Absolutely.
So yeah. Oh, go ahead.
Oh, I was just gonna add to that. Like, it's I do want to recognize, of course, it's becoming more and more common to have these scent-free policies, and it's not the same situation that it was many many years ago, for sure. There are still barriers, but definitely, there has been some progress over the
Oh
years,
yeah.
for sure.
And I mean, scent or fragrance free policies could play a big role in supporting people with MCS. How should workplaces go about creating and enforcing these policies, and what could they do to make sure employees understand and follow them?
Yeah. So. It's a bit of a tricky question for me as a staff lawyer at Arch, and I'm going to explain why. Um, Essentially, so at Arch, we do advise employees who are non-unionized, but we really focus on the employee side of things. So we don't necessarily provide advice to
Okay.
workplaces and organizations about how they can do their own policies. The reason for that is, and this is just really a rule with related to lawyers, right? We don't want to be put
Yeah.
in a conflict.
Yeah. Of
Um,
course.
yeah, so we wouldn't be able to, we don't tell people specifically how, or don't tell employers how to do their job, or how to write their policies. I do want to say one thing, and I think I've repeated probably a few times now, but if I could say one general message, that employers have to remember their duty to accommodate their employees with MCS. That is the
Yeah.
main thing. However that looks like, that needs to happen. And in Ontario specifically, the Ontario Human Rights Commission does have some resources for employers that they could look at. And I can imagine that, in other provinces, they may also have something similar, or hopefully they have something similar. I can't confirm it, but at the very least in Ontario, there is the Ontario Human Rights Commission that provides some information for employers. Regarding, send free policy specifically as well. So that'd be a good resources for people.
Yeah. And I know you mentioned undue hardship and accommodation a few times earlier, but I do have a note here that to ask you about. Under the Canadian Human Rights Act, accommodations are required unless they cause undue hardship. How do we define undue hardship in cases of MCS, and what factors come into play when determining whether an accommodation is too difficult or expensive to provide?
Yeah, so undue hardship, again, whether it's under the Canadian Human Rights Act or the Ontario's Human Rights Code, it's the same
Mm-hmm.
definition. So
Okay.
so just so everyone is on the same page about that. Um, undue hardship is the a limit to the duty to accommodate in a sense. And I'll explain a bit what I mean by that. But first, when we talk about something that is undue hardship or an accommodation that is undue hardship, we're talking about an accommodation that is excessively costly, including, after considering if there's any outside sources of funding available, or that the accommodation could bring health and safety concerns in one way or another. So I'm going to talk first about generally, what that could look like in terms of the duty to accommodate, and then I'll speak more specifically to MCS. Um, but more generally, when we talk about cost, it's not just the fact that something will cost the company or the service provider or whoever is providing the accommodation, that will cost them some money because that's a given. It's going to cost, for the most part, it's going to cost money. There are some accommodations that cost nothing, but some of them cost. That's not undue hardship just because the organization has to spend some money. It has to be some um, a cost that is so excessive that essentially would go to the core of the business operation of the actual organization, that there really is nothing in the budget to cover this. So it's really, it's a case by case situation. There's no magic number. What's undue hardship because of costs for a mom and pop shop may not be the same amount for a multinational company, right? Um, so it's really, specifically in that sense. And health and safety concerns, I mean, that's also a case by case, whether there's health and safety concerns related to providing the accommodation or the accommodation itself, or the situation is bringing health and safety concerns that cannot be, that would cause really that undue hardship to the organization or service provider. So even if an organization can successfully claim or claims even undue hardship, and to say then that, well, this is undue hardship for us, we cannot accommodate you. That's not necessarily true. It does not, just because something is undue hardship or reaches the point of undue hardship, that does not necessarily mean that the organization, service provider, whoever, no longer has a duty to accommodate. What they do have to do is that they have to find, or they have to try to find an alternative accommodation that would not reach the point of undue hardship, but will still meet the needs of the person. So just because something is undue hardship, that is not the end all and be all of the person's duty to accommodate. Now, in terms of specifically cases for persons with MCS, it's still the same, either it's cost or health and safety concern that will be considered undue hardship. Um, So those are still the considerations and factors that needs to be taken into account in terms of accommodating that person. Um, Now, and we're talking specifically about undue hardship as that limit, as opposed to maybe some other specific potential limits or potential challenges, which I can talk briefly about as well afterwards. Um, it's really whether or not an accommodation is too difficult to provide. And I'm thinking again of Century policies. Um, that's not a factor. That would not be considered undue hardship. Something that's too difficult is not undue hardship. The organization may try to make it seem like it is, but that is not the test. It's really just, is it excessively costly? Is there any health and safety concerns? That's what undue hardship is. And if they're saying it's costly, then they have to show it. They can't just say that there's going to be a cost. Like if I could say an example of replacing the cleaning products in that are used to clean an office, so that it's scent free or fragrance free or chemical free, as opposed to what's been used before. Sure, that's going to cost money, obviously, but is that undue hardship? Is that excessively costly? And that's has nothing to do with the fact of whether or not it's expensive. It doesn't matter if it's expensive. It just matters if it's excessive cost to that creates an undue hardship in terms of really, really going to the core of the budget of the organization. And that's pretty rare that's where I could see that actually happening. There are in terms of in cases of MCS, there may be other considerations or other things that may come into play that may be beyond undue hardship, because for the most part, I think that's not necessarily where it lies. Where the issues lie is mostly in terms of you know creating that space, or creating those or trying to find a creative manner to accommodate the person's needs. That could be, I could use the example of a doctor's office. I think that might be the more straightforward one that I could think of right now. A person living with MCS needs to go have a doctor's visit. It's in person at their office. The office may be scent free. Employees are scent free. The doctor is scent free. So that's all great. But it's an office that's open to the public. They may or may not be able to always control who's coming into the office or who has been in the office, right? Before the person's visit. So that person who's living with MCS may need some additional accommodations beyond just a scent-free policy. And because of the actions of the members of the public, right? That the doctor may or may not, I mean, there are situations where they may have some control, but they may not have control all the time. And when I'm talking about control, I'm talking about like legally have control. So in that sense, it could be difficult, right? To accommodate that person to have a scent-free environment when they go see the doctor. So then there is that duty to accommodate from the doctor. So, okay, let's think about other ways that we could provide you with medical services in a way that will meet your needs and that you could be able to actually have access to our office. That could look like different ways. I could give a few examples, but in no means are my examples the only ways, because obviously, as we mentioned earlier, everyone's individualized, right? Their needs are individualized. But some example would be if they could be offered a virtual appointment. That could be something that could work. be that person is the first patient in the morning before anyone else comes in, right? That could also be a workable
Yeah.
accommodation, right? So,
Yeah.
so there are ways around it that goes a bit beyond undue hardship itself. But it's important to know that there are some limits at times to the duty to accommodate.
Yeah. That's some really great information for our listeners. I know you've mentioned like the doctor's office and public spaces. So my next question is more about addressing social isolation and public access. So it's completely related to what you were just uh, talking about. Like MCS could create real barriers in participating in everyday activities like going to the doctor, riding public transit, or socializing in public spaces. What could the law do better to ensure people with MCS could access these spaces without discrimination?
Yeah, so as the law stands right now, there's not much, or it's a bit difficult to legally enforce, that kind of those kind of barriers, or to erase those kind of barriers. But and I've mentioned this a few times during our conversation that there are some difference between what is protected by human rights law and what isn't. But I think in a more general sense, um, what the law in general could do better, or what could happen or should be happening, is that there is uh, adopting this concept of universal design, right? Accessibility laws that are already in place, or maybe could be strengthened, uh, those can play a role in making society, public spaces more accessible in a proactive way, right? Just like ensuring that new buildings are always accessible, right? They're built from the get-go
Yeah.
as being accessible before someone asks. That's what universal design means, right? It's ensuring without having to be asked, ensuring that the space is accessible from the get-go. And that's probably where, that would be a way to ensure that people living with MCS can have access to those spaces without facing discrimination. And it's may or may not necessarily be through human rights law specifically, just because they're very focused on what areas that they can come and play. But accessibility laws may be a bit more general and bring in that concept of universal design.
Yeah. Or even the way in most elementary schools they've banned peanut products to protect children that have might have peanut allergies or have peanut allergies. So that kind of enforcement has just kind of trickled down the whole line, and now there's a genuine respect of not bringing uh, peanuts into a school because it might harm somebody else. So I think these public spaces could become scent free by policy, and therefore if you're entering a hospital or you're entering a clinic or you're entering a public transit and you're not allowed to to wear a scent, or then it would truly become a universal design,
Absolutely, absolutely. And in that sense, it becomes more accepted,
yeah.
right? It takes time to reach
Takes
that
time, yeah.
level, but yeah, you're absolutely right. Now people are more not necessarily thinking they're allowed or not allowed, but they are aware that this can affect other people. For example, like your example of the peanut allergy, you're aware that this can affect other people, so I don't want to bring that into that space just in case. And that's through universal design, through the policies, while it's being more and more accepted, that there's a hope that that could be brought into people's minds as well.
Yeah, and as you mentioned earlier, educating, right? Educating is always the most widespread way to get something known.
Absolutely. Absolutely.
So, in terms of advocacy and legal resource, if someone with MCS feels their rights aren't being respected, whether in the workplace, housing, healthcare, what legal options do they have to stand up for themselves and get the accommodations they need?
So just in case, this may not have been that the person hasn't done this yet, I think that if they're being denied an accommodation request or or they feel like they're being discriminated against, then if they haven't done so yet, to just ask them to ask to speak to someone who's in charge, right? At the workplace would be, if it's your employee that is causing these issues, um, for example, then speak to the employer or someone, HR, local HR or whoever. In healthcare, speaking to the receptionist, they don't want to accommodate. There is someone higher up. And sometimes, that could resolve it quickly. Um, but in terms of, if you are still, or if the person is still not getting the accommodations or they're being discriminated against, I think the number one thing is to speak to a lawyer, right, about your specific situation. Because some of times it could be simply the option would be to make a formal complaint. There may be some places that have complaint mechanism already in place. For example, in healthcare, they have colleges of physicians, for example. And that may be a proper avenue to make a complaint. Not always, but there are situations that it could be a situation. Other times it would be to file a human rights complaint against service provider or your employer. Um, but so there could be a different complaint mechanism or processes to that you could take. Um, really depends on each situation. A lot of the times it would probably be a human rights complaint, whether if it's in Ontario and under provincial jurisdiction, that would be a complaint at the Human Rights Tribunal of Ontario. At the federal level, which is any place that is under the Canadian Human Rights Act jurisdiction, that would be a complaint at the Canadian Human Rights Commission, which is also a tribunal, but or part of a tribunal, but it's a different one and it's at the federal level. Um, and those complaints are essentially, it's like bringing a lawsuit, basically, but it's in the human rights context. There are other options that in other situations that it may be an internal complaint that needs to happen because of that particular area, right? I could talk a little bit about healthcare. There may be potentially um, a situation where a human rights complaint may not be the right way to go. It may be through a different complaint mechanism that is in place and specific to healthcare, for example. So all that to say is that the first thing maybe to think of is to talk to a lawyer, especially with many complaints that, including human rights complaint, there may be some limitation period, which means that there are deadlines of when you can file. So it's important to, so that if you file after that deadline, and the deadlines are different in every single type of complaint process, but if you file after that deadline, you may not be able to make a formal complaint, and it may be rejected just because it's what we call out of time. So consult a lawyer as soon as possible about your specific situation. They could give you very specific options to your situation. And there may be also situations that your legal option is not necessarily to file a human rights complaint or file a complaint somewhere else. It may be that okay, no, actually right now you need to go, you need to get to try get me with this person and that person because you're still need to go through the accommodation process, right? There are times um where someone is in the middle of the accommodation process, but may feel like they're not it's not progressing or that, you know, it's not going fast enough. They're still consulting or they're asking too many questions, right? But that doesn't always necessarily mean that's a human rights complaint. Sometimes it's just part of the accommodation process. And before filing a human rights complaint, generally you have to, you know, see through that process to some extent. If you are a person with MCS living in Ontario, and you have and your issue is an issue that happened in Ontario, then you could also contact Arch for free legal advice um, for your situation. We're happy to take that to take your call and to talk to us. We're several lawyers here that we could do that. And I'm happy to, you know, if possible, I could provide our phone number, or whether it's on the website or available for people to contact us. If you're in another province, um, then you would probably need to contact a lawyer from that practicing in that province. And if you are an employee who is part of a union and your issue is related to your workplace, then contact your union representative for advice because they're there or they should be there to help you if you are being discriminated or not getting the accommodations at work. Specifically, if you're not unionized and you're in Ontario, then we could give some advice from that perspective as well.
Yeah. Well, yeah, that's one thing I was gonna say. It's great that in Ontario, um, people with disabilities have the resource of having some free legal advice. I'm sure in different provinces they have different law firms that also offer the same resources, because obviously sometimes people that face these situations don't necessarily have the means
Mhm.
or the funds to be able to afford a lawyer, but I'm sure we could provide on our end as well, find for each province which which association, or if you're familiar with any, we could also list them on our website. But obviously, I'll also post your information on the screen when you mentioned it, so at least people could have access to Arch Disability, especially if they're in Ontario. And in terms of final thoughts, Lila, thank you so much for sharing your insights today. It was really great. This conversation has been really valuable to our community. Before we wrap up, is there anything else you'd like to share with our listeners?
Yeah, no, first off, I want to thank you for the opportunity and for inviting us to speak today. I know that we talked about a lot of things, a lot
Yes.
of information
Yeah,
for
yeah, yeah.
people. I think if I could sum it up in like 3 points, for people to just, if you're gonna take anything, like 3 points only to from our conversation today is remember MCS is a disability that's recognized under human rights laws. That means that there are legal rights that exist and protections that you have, including protection against discrimination because of MCS, and the right to get accommodations for any needs you have related to MCS. Um, and the second point is if you are not sure what to do, if you know you're trying to get accommodations from your employer, for example, the employer is telling you XYZ, you don't know what that means, contact a lawyer. You know, they would be just they'd be able to tell you specifically in your situation what to do next. It doesn't matter if you're at the beginning of the accommodation process and you're not sure how to proceed, or you're in the middle of it, you don't know what's going on or what to do next, or you've been denied and you want to know where to file a complaint. It's better to ask the question so that you know your rights in your particular situation. And finally, if you're specifically living in Ontario, and of course the issue happens in Ontario, then you can contact Arch for free legal advice. And in other provinces, as you mentioned, Marco, there is probably other kinds of resources that hopefully could also be available if you're residing in those provinces as well. So I think really remember there are rights that people living with MCS that they have under human rights law, and it's important to be aware. And if you're not sure, then ask a lawyer.
Yeah. Well, thank you so much, Lila. This I'm sure our listeners will have a lot of information to go through, and that's the beauty of podcasts. They could always pause, rewind, re-listen, and again, thank you so much from the parts of the Environmental Health Association of Canada and the Environmental Health Association of Quebec. Thanks for tuning in to this episode of Footprints and Impacts. If you found value in today's conversation, be sure to subscribe, leave a comment, and share it with friends, family, and especially someone who might benefit. Don't forget to follow our upcoming episodes for more insights on sustainability, health, inclusion, and how we can all make a positive environmental impact. Until next time, stay curious, take care of yourself, and be well.
This podcast is part of the Empowering Community and Removal of Barriers project, funded in part by the Government of Canada's Social Development Partnerships Program, Disability Component.